Hi there, this is another video of the Maxim game. In the previous video, we have learnt about the Maxim acta exteriora, indicant interiora secreta, which meant that external acts indicate the intention behind. We have also learnt about the applicability of this maxim under the various laws. In the previous video, we discussed the applicability of the maxim under the law of torts, under the law of crimes, contracts, and Specific Relief Act. In this video, that is the next chapter of the Maxim game, we will deal about absoluta sententia, expositor non indiget. So this entire video is about the meaning, applicability of the maxim, the origin of the maxim, and the exceptions to the maxim. The maxim absoluta sententia expositor non indiget derives its origin from the Latin term. It is a Latin maxim, and it means that a simple proposition requires no explanation. A thing which is plain and simple requires no explanation. Likewise, any law or any provision of law which is in plain terms, clear and simple, requires no explanation. In very simple terms, this means that each and every law, statute, or code which is formed by certain words formulating into certain provisions, if involve simple words and plain words, then the provision should be read as it is and it requires no further interpretation. This is how the maxim absoluta sententia expositor non indiget is connected with the laws, statutes, and code, be it applicable at any place. Since each provision, every code of any act or statute or a law is made by words which, if plain and simple, then it will not require any further explanation. This is how this maxim absoluta sententia expositor non indiget finds place in the legal system. And the applicability of the maxim is very general in the common parlance. It can be made applicable to the rules of interpretation also. We all know that every code, every act, every statute can be understood only by applying certain rules of interpretation. So this maxim is nothing but an enriching hand to those tools of interpretation. The rules of interpretation are the major tools with which almost all major documents and minor documents of laws, statutes, and acts are read. These rules help in decodifying the purpose behind a particular provision of law. Since the rules of interpretation are tools which help in decodifying the laws and provisions of law, it allows a provision to unfold its horizons so as to let it to apply upon a situation. The very fundamentals of the rule of interpretation is the literal rule of interpretation, the liberal rule of interpretation, the strict rule of interpretation, the purposive interpretation, and the hedon's rule of interpretation or the mischief rule. It is important to understand the rules of interpretation in this video because it has direct connection with the maxim. The maxim deals with the wordings of law, code, or statute. And the rules of interpretation deals with decodifying those wordings, formulating a provision under a law, statute, or a code. Therefore, there is a direct and connected link, or in other words, we can say that it is an interconnected link between the rules of interpretation and the maxim absoluta sententia expositor non indiget to make the laws, codes, and statutes functional. The literal rule of interpretation. The literal rule of interpretation is one of the tools used in understanding the purpose of a provision of law or statute. Literal rule of interpretation is taken as plain and simple. It is often read as it is, and the provision of law applies as it is. Now, the maxim absoluta sententia expositor non indiget finds place in the literal rule of interpretation. In other words, we can say that the literal rule of interpretation includes within itself the plain and simple reading of the act or any provision of the law, which requires no explanation. It can be also said that the literal rule of interpretation is an enriched and extended branch of the maxim absoluta sententia expositor non indiget. This can be explained by an example. For example, under Article 52 of the Constitution of India, it has been clearly said that there shall be a President of India. Now, the wordings of the law is very simple and very plain. So this means that India should have a president. We cannot dwell into any other meaning of this particular provision of the law. It is very plain, very simple, and crystal clear. There needs no explanation. Another example is under Section 37 of the Indian Contract Act, which lays down an obligation upon the parties who willingly entered into a contract to perform the conditions and terms of the contract. Now, the wordings of the Section 37 of the Act is also plain and simple, and at the same time, it does not require any explanation. Further, if we can move on to Section 52 of the Indian Penal Code 1860 or the newly amended Sanhita 2023, there also acts done in good faith forms a general exception and calls for no punishment. So all those acts, the intention behind which is good faith, bona fide intention, causing no harm to others, can be taken as it is and can be applied to any situation and circumstance of the case as it is, because it is very plain, crystal clear from the wordings of the law, and it does not require any explanation. That is how the maxim absoluta sententia expositor non indiget enhances the literal rule of interpretation. The liberal rule of interpretation, that is the second rule of interpretation, it applies when the text is plain and simple, but it requires an unfolding of the provision itself so as to apply to the circumstances of the case. Despite the provision being plain and simple, there is a need for unfolding of the provision in order to fulfill the needs of the case to which it is being applicable. The maxim absoluta sententia expositor non indiget finds place in this rule of interpretation when there is ambiguity about the plainness of the provision of law or statute of the act. When this ambiguity is cleared by application of liberal rule of interpretation, then the ends are met. In the prior video, the literal rule of interpretation was a modified form of the maxim absoluta sententia expositor non indiget, whereas this liberal rule of interpretation is an extended form of the maxim absoluta sententia expositor non indiget. And in all cases of ambiguity where despite the provision of the code, law, or statute being straight and simple and plain, there is a need to clear the ambiguity. And that ambiguity can be cleared only by unfolding of the provision so as to make it applicable to the circumstance of the case. When the ambiguity is cleared, the provision of the law applies plainly to the circumstance of the case. Ambiguities or ambiguous conditions are nothing but conditions which are vague to its very nature, conditions which are unknown to its very nature. The vagueness and the unknowingness of a certain situation, circumstance, or condition leads to a situation of ambiguity. In cases of ambiguity about a provision of law or act or statute, there exists the rules of interpretation. We have already seen that these rules of interpretation are nothing but the golden tools which helps the wordings of the law to apply to a particular situation, circumstance of the case, so as to arrive at a single conclusion. In general, the legislators have tried to make the text of the code or statute or act plain and simple. This is done to avoid chaos. But there are certain cases where there is need of an unfolding of the closed horizons of the provision. It is this need which calls for specific rule of interpretation to apply. In general terms, there are three cases of ambiguity in law. The first case is when there is a provision in law but it is not clear. There are cases where there is law but the wordings of the law is not clear. In situations like this, where there is a provision in law but the provision is not clear by the wordings of the law, then we apply the liberal rule of interpretation so as to achieve the ends. Another case of ambiguity is that when there is a provision in law but it is not applicable to the situation. Now, there are cases where there is a provision in law about a particular situation or circumstance, but there is ambiguity in its applicability. In simpler terms, there are wordings of law, code, or in any statute which seems to be applicable to a particular situation or circumstance, but there is ambiguity as to its applicability, that is, how it will be made applicable. And the provisions are silent independently on the issue. Let us understand this by an example. For example, let's take IPC or the new Sanghita 2023, but it will be easily understood by the IPC 1860. So we will see IPC 1860 only. In IPC, Section 2 punishes a person for acts which are committed within India for the law under which he is made so liable. So, Section 2 will call for all those people who have done acts which is capable of being punished by the laws in India to be made punishable. It does not talk about acts which are done by person outside India which requires to be called for punishment under the legal laws, as those acts are made punishable under the IPC itself. Now, Section 4 deals with such kind of acts. Section 4 provides punishment for extraterritorial offences for acts done by any person which is made illegal by this code. So, the applicability of Section 2 is independent. The applicability of Section 4 is independent. Now, suppose a person who is of any origin commits act beyond India for which he would have been made liable in India had he committed that offense within India. Is there any provision which will punish such a person? So, Section 3 calls for a solution to this problem, and therefore, Section 3 acts as a connecting link between Section 2 and Section 4, which are independent sections of independent applicability on independent territorial expansions. Therefore, in such cases of ambiguity, a legal fiction is created and the presumption is raised so as to make two different independent sections of independent applicability to intertwine on a particular situation or circumstance which needs such an interconnection. Therefore, these cases acts as an exception to the maxim absoluta sententia, expositor non indiget. Despite the wordings of the law being plain and simple, it arises a case of ambiguity wherein there is a provision of law but it is not applicable to the situation. In such cases, legal fiction is created and it is presumptions are raised that an interconnection will be created so as to make these two independent laws working independently to work together. Therefore, if we read section 3 of the IPC 1860, the words of the provision of the law is not very vague. It is in simple terms. It is plain. But when it comes to its applicability, the explicit terms cannot help to resolve a situation. Rather, what is implicit behind the terms gives solution to such problems. As a result, in such situations, liberal rule of interpretation applies. Now, the liberal rule of interpretation has two branches. First is purposive interpretation, and the second is the hidden's rule or the mischief rule. Now, the purposive interpretation applies in order to fulfill the purpose for which the law is laid down, and the hidden's rule or the mischief rule is applied in order to take out what the law wants to say but is not explicitly clear by the wordings of the law. The third case of ambiguity arises when a situation arises and there is no provision in law. Now, there are cases where there is no provision in law as to a particular set of circumstances in a case. Now, this is an exception to the maxim absoluta sententia expositor non indiget. How this forms as an exception? Because the maxim says that there has to be something in the form of words which is plain, simple, not vague, to serve the purpose of the law, to serve the purpose of the situation at hand. But in this case of ambiguity, there is no provision itself, and the situation has arisen. So, how we will move on to the solution? So, the solution to this problem is solved by invoking the inherent powers of the court. The inherent jurisdiction is given to the courts, be it in the matters of criminal nature or be it in the matters of civil nature, to serve the justice at the best and to provide the litigants and ends to justice. For the purposes of this kind of ambiguity, Section 482 of CRPC calls for an inherent jurisdiction on the High Courts, and Section 151 of the CPC calls for inherent jurisdiction of courts. In such kinds of ambiguity, there is no other alternative remedy, and the only remedy is invoking of the inherent powers of the court. And the solution will be the solution which the courts will decide. Appreciate your time. May this video be useful and helpful to you. and will come up with other videos also. This is Shruti Pandey. You can contact me at shrutipandey.alsn@gmail.com and can also follow me on my Instagram channel lex.shruti. Thank you. Don't miss to follow, share, and subscribe.